You suffered injury because of your careless doctor, and now you're trying to decide whether or not to bring a lawsuit. And you heard that if you do bring a lawsuit, you will have to give testimony, pre-trial testimony known as a deposition in your particular case. But you have some concerns and questions, and you need to know, what is this deposition, and how is it going to affect me if I say the wrong thing during my deposition? You want to know the answer? Come join me on this walk through the neighborhood as I share with you exactly the answer to the question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you believe that your doctor was careless, causing you significant harm and injury. You go to an attorney who has your medical records evaluated by an expert who does in fact confirm that yes, your doctor was careless, and yes, his carelessness was a cause of your injury, and that your injuries are significant and permanent. You learn that by going ahead and bringing a lawsuit against your careless doctor, you will have to go ahead and give pretrial testimony, which means you will have to answer questions from the defense lawyer, the lawyer who represents the doctor whom you intend on suing. And now you're going to have to sit in your lawyer's conference room all day and answer questions. And now you're wondering, can you do that? What happens if you say the wrong thing? What happens if you don't remember the answer to certain questions? Will it destroy your case? I'll tell you what happens. When you go ahead and bring a lawsuit against your doctor, after the defense attorney, the attorney who represents the doctor, has had an opportunity to gather all of your medical records, they will have them reviewed by one of their own medical experts. And then shortly after that, there will be a time where you are scheduled to come into your lawyer's office, to sit down and to be questioned by the attorney who represents the doctor whom you have sued. There's no judge there and there's no jury there, and this takes place in your lawyer's conference room. But you should know that there is a court stenographer there, a court reporter there, to record all of the questions that you are asked and all of the answers that you give. Now, why is that? It's because the answers that you give represent your sworn testimony, and that carries the same exact weight as if you are testifying at the time of trial. Okay, so what's the big deal? The big deal for a lot of people is that they think, wait a second, a lot of time has gone by since this event happened, since this malpractice happened. And now it's been 2 years, sometimes even 3 years, maybe even more. And now you don't remember a lot of the things that you did. What's going to happen if the attorney asks you questions and you simply don't remember? Will that destroy your case? For the most part, the answer is no. What will happen in the days leading up to this scheduled deposition is that your attorney will sit down with you and now go through with you the events that actually happened years earlier. The attorney will refresh your memory about certain things that took place, remind you about various dates where you were seen by particular doctors. Now, you will tell him and explain to your attorney during this preparation session about what it is that you do remember. And now, at the appropriate time when you are questioned during your deposition, in all likelihood, now you will have a refreshed memory of the events that transpired. But now you're thinking, wait a second, what happens if I still don't remember? What happens if I freeze with that deer in the headlights look and he asks me a question to which I don't know the answer? The reality is, nothing will happen. You'll simply tell the attorney, I'm sorry, I don't remember. And if you don't remember a number of times, the defense attorney might turn around and say, okay, Mr. Jones, would it refresh your memory if I told you that this took place on January 5th? Oh yeah, now it does. Now I remember. Now, if you don't remember something, fine, tell him you don't remember. He might offer something to refresh your memory and then ask you, okay, does that refresh your memory? Either it does or it doesn't. So the key question that often comes up is, will it change the outcome of your case? In all likelihood, the answer is no. One of the reasons why the defense wants to question you is because they want to lock in your testimony. So if you go ahead and answer, I don't know, I don't know, I don't know. What do you want from me? I don't know, I don't remember. And now you continue to say you don't remember because you're tired, you're frustrated, or maybe really you just don't remember. Okay, but now your case comes up for trial a year and a half later. And now at trial, you're asked the same exact questions. If all of a sudden now at trial, you go ahead and say, oh yes, I remember, and now you give the answer, now the defense attorney will have an opportunity to cross-examine you on those points and argue, look, I asked you those same questions a year and a half ago, and you didn't remember. Are you telling us that now your memory is better, so many years later? And of course, you'll have to explain why you remember certain things now. Maybe you read something in preparation for your testimony at trial, or there could be other reasons why you might remember something now that you didn't remember in the past. So, why do I share this with you? I share this with you because oftentimes people are concerned, they're anxious as they're trying to decide whether or not to bring a lawsuit against their careless doctor, and they're wondering what's going to happen if I do bring a case, and now I have to give testimony in my deposition, and I don't remember everything that I need to. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.